Ready, start. While the grounds of detention are thus the main factors on which the subjective decision of the government is based, other materials on which the conclusions in the grounds are founded could and should equally be conveyed to the detained person to enable him to make out his objections against the order. Full stop. To put it in other words, the detaining authority has made its decision and passed its order. Full stop. The detained person is then given an opportunity to urge his objections, which in cases of preventive detention comes always at a later stage. Full stop. The grounds may have been considered sufficient by the government to pass its judgment. Full stop. But to enable the detained person to make his representation against the order, further details may be furnished to him. Full stop. In our opinion, this appears to be the true measure of the procedural rights of the detained person under Article 22 within bracket 5. Full stop. The conferment of the right to make a representation necessarily carries with it the obligation on the part of the detaining authority to furnish the grounds, that is, materials on which the detention order was made. Full stop. It is therefore clear that while there is a connection between the obligation on the part of the detaining authority to furnish grounds and the right given to the detained person to have an earliest opportunity to make the representation, the test to be applied in respect of the contents of the grounds for the purposes is quite different. Full stop. As already pointed out, for the first, the test is whether it is sufficient to satisfy the authority. Full stop. For the second, the test is, whether it is sufficient to enable the detained person to make the representation at the earliest opportunity. Full stop. The argument advanced on behalf of the respondent mixes up the two rights given under Article 22 within bracket 5 and converts it into one individual right. Full stop. We are unable to read Article 22 within bracket 5 in that way. Full stop. As pointed out above, the two rights are connected by the word double inverted comma and double inverted comma close. Full stop. Furthermore, the use of the words double inverted comma as soon as may be double inverted comma close with the obligation to furnish the grounds of the order of detention, and the fixing of another time limit, which, the earliest opportunity, for making the representation, makes the two rights distinct. Full stop. The second right, as it is a right of objection, has to depend first on the service of the grounds on which the conclusion, that is satisfaction of the government about the necessity of making the order, is based. Full stop. To that extent and that extent alone, the two are connected. Full stop. But when grounds which have a rational connection with the ends mentioned in section 3 of the act are supplied, the first condition is satisfied. Full stop. If the grounds are not sufficient to enable the detainee to make a representation, the detainee can rely on his second right, and if he likes may ask for particulars which will enable him to make the representation. Full stop. On an infringement of either of these two rights, the detained person has a right to approach the court and complain that there has been an infringement of his fundamental right, and even if the infringement of the second part of the right under Article 22 within bracket 5 is established, he is bound to be released by the court. Full stop. To treat the two rights mentioned in Article 22 within bracket 5 as one is neither proper according to the language used, nor according to the purpose for which the rights are given. Full stop. This detailed examination shows that preventive detention is not by itself considered an infringement of any of the fundamental rights mentioned in Part 3rd of the Constitution. Full stop.